Good afternoon. We are here to discuss privacy, confidentiality, and the role of the school counselor.
This is an in-service provided by the school counselors to the entire school staff about the ethics and legalities regarding confidentiality. Confidentiality guarantees that professional school counselors will not share students' disclosures with others except when the students authorize it or when there is a clear and present danger to themselves or someone else. These issues are dealt with on a daily basis by school counselors. Research literature supports that confidentiality is the main focus for students when entering into a counseling relationship with a professional school counselor. Confidentiality is also an essential function between the role of professional school counselors and the role of teachers and principals. We will address the responsibilities that we have to parents, students, and the school in regard to the confidentiality. We will also address the legal ramification for everyone if confidentiality is broken. We will learn about who has privileged communication, informed consent, and what happens when confidentiality is broken as a mandated reporter. As an educator, are you held liable?
The main objective here today is to define confidentiality and privacy as it relates to students, parents, and school personnel. We also plan to identify when confidentiality can be breached. And another objective is to ensure that all stakeholders are knowledgeable and that we work together ensuring that all ethical, legal, and district policies are upheld when working with students. The legal status of minors. Because we work within the school system, we primarily work with minor students, that is, students under the age of 18. Students do have the right to confidentiality and privacy in the counseling relationship. However, because of their age, these rights ultimately belong to their parents. This makes for a very complex relationship between school counselors and students in maintaining their confidentiality and privacy. According to Lewowski, maintaining student confidentiality and privacy has been described as one of the major ethical dilemmas of school counselors. And believe it or not, this is something that school counselors face and deal with on a daily basis. School counselors, we play an integral part in always maintaining not only the rights of the student, but also we try to keep in mind the concerns of the stakeholders like teachers and administrators and parents as well. Our main responsibility is to advocate for the student and to be sure that their rights are always kept in consideration. The counseling relationship. Whether you work within the school system or in private practice, the counseling relationship is a very, very important part, especially as it relates to the school counselor and the student. It depends heavily on trust. And because we are working with minors, sometimes it's almost impossible to maintain that trust in many levels. It is important that school counselors, students, parents, and staff alike respect that counseling relationship. There may be times where we may not be able to share with you all aspects of a student's issues or relationship issues they're having. So just respect that because we're trying to maintain the trust between student and counselors. In addition, with that being said, students should be made aware of confidentiality and what situations will warrant a breach of that confidentiality. The counseling relationship continued. Counselors adhere to the following moral principles when assuring that confidentiality and privacy is maintained within the counseling relationship. Veracity or truth-telling or telling the truth is always an important principle. Justice or fairness. We always want to make sure that we are fair when working with our clients. We try also not to do any harm to our clients. We also want to do good. We also want to help clients remain autonomy and respect their free choice. And we also want to uphold fidelity and or keeping promises.
Informed consent is both a legal and ethical principle requiring school counselors to adequately disclose to clients potential risks, benefits, and alternatives to proposed counseling. Minor clients, however, cannot legally give informed consent. Only their parents can. Although the majority of clients served by school counselors cannot legally give informed consent, they can assent to counseling without parent consent. Some school districts or school principals have policies that require counselors to obtain parents' permission before beginning counseling students, and others require counselors to seek permission if they see a counselor more than a specified number of sessions, for example, 2 or 3. Unless there is a school policy or a state or federal law to the contrary, it is asserted that school counselors do not need parental permission before they provide counseling to students.
Parents and confidentiality. Assure parents that they will be informed if the child is believed to be in harm's way. Approach parents as allies or partners in the counseling process. They are not your enemy. Begin the school counselor by informing parents of the role of the school counselor. And when parents insist on breaking confidentiality because they have rights, educate parents about the counseling process. School personnel and confidentiality. Counselors conduct in-service sessions with school personnel and are present at PTA meetings. Look for opportunities to interject information about your confidentiality policies. Establish a trusting relationship with teachers and administrators. Learn to deflect or address requests for confidential information. Give your principal a copy of the ASCA Ethical Standard of School Counselors.
Privileged communication. Interaction between two parties in which the law recognizes a private, protected relationship. Whatever is communicated between these pairs of parties shall remain confidential, and the law cannot force disclosure of these communications. Counselors' ethical obligations to maintain confidentiality does not allow them to disobey a court order to disclose information relevant to legal proceedings. In order to legally maintain the confidentiality of clients' communications or counseling records in judicial proceedings, the communications or records must be protected by a legal privilege. Privileged communication allows clients to ask counselors to keep their communications and records of those communications confidential. Privilege belongs to the counselee, and the counselor acts for the counselee in asserting privilege. Unless privilege exists or is granted, counselors can be compelled to disclose counseling notes and information given to them by clients or face contempt or court penalties. The concept of privileged communication is contrary to the philosophy of rules of evidence in court proceedings. The legal requirement to reveal information in court, unless a privilege has been granted, is grounded in evidentiary law established to allow courts to seek the truth. The traditional standard for privilege is that the communication originated in confidence. Confidentiality was essential to the relationship. So society wants to foster the relationship, and the harm caused by breaking the trust would not be offset by the gain for justice.
Are there times where you must break confidentiality? The answer is yes. Legal requirements can demand that confidentiality be broken. And I have been subpoenaed several times over custody situations. Anything that I have put on school flash drives, computers, voicemails, school legal pads, any of that information can be used in a court of law. Be very careful about what you're actually putting on your notes. You can be required to submit that information. Confidentiality must be breached to prevent serious and foreseeable harm to the student. This can be different depending on the developmental and chronological age, the settings, parental rights, and the nature of the harm. For example, if you have a 15-year-old that is spending all afternoon by himself while the parent is at work, this may be something that you don't agree with, that you feel like is a bad parenting decision, but it's not breaking the law. If you have a 5-year-old that is spending the afternoon while the parent is at work, that's something totally different. That is something that is breaking the law. That is something that does need to be reported, and that is not just something that you don't agree with. And this is something that we have to deal with every day as a school counselor. Every situation is different. Situations are subjective. Some things we just don't agree with as a parent. Some things are bad parenting decisions, but they don't break the law. Some things have to be reported. Some things we have to consult with other counselors. We have to consult with administrators because there's kind of a gray area. Also, we need to explain in advance to our students. The easiest way is during classroom guidance settings at the beginner. that there are times where we must break confidentiality, that we are mandated reporters, that there are times that if someone is hurting them, if they are hurting themselves, or if they are hurting someone else, that we will lose our job if we do not report this, that we can be held criminally responsible if we do not break the confidentiality. And also that especially if they're going through any kind of custody agreements, disagreements, if there is a possibility that they foresee that they're going to be going to court, there's a likelihood that the counselor is going to be subpoenaed if they're going to the counselor. So those are situations that they need to be made aware of, that their confidentiality may be broken. When parents leave their child at school, they expect their child to be taken care of. They expect their child to have counseling if they need it. They expect their child to be taken care of. They expect their child to be fed, be taught. And you must respect that parent or guardian's right to properly care for their child. Children have an ethical right to privacy, but the parents have a legal right to know what was discussed. So if a parent calls and wants to know what you talked about to that child, you have a legal right to talk to that parent. You do not have to tell them everything, but you do have to tell them basically what was discussed with that child. This is a fundamental conflict that all school counselors face. That was mentioned earlier. This is something that you there's a fine line between informing parents and also feeling like you have betrayed that child. Complete disclosure, as mentioned, is not required to be given to the parent, and some discretion needs to be provided, because you can ruin that relationship with that child and they will never talk to you again. So you need to be careful with following through with the legal rights of that parent, but also trying to keep some of the confidentiality still in place with that child. With student records, in accordance with ASCA, you must protect confidentiality of student records and release personal data in accordance with prescribed federal and state laws and school policies, including laws within FERPA, Family Education Rights and Privacy Act. Student information stored and transmitted electronically is treated with the same care as traditional student records. And many times you'll have records requests that you fax, or they are one of them emailed. And regarding sending them electronically, it also says to recognize the vulnerability of confidentiality in electronic communications, and only to transmit sensitive information electronically in a way that is untraceable to students' identity. To me, this is saying to redact that information with their name, their social, critical information such as a student who has history of suicidal ideation must be conveyed to the receiving school in a personal contact, such as a phone call. So nothing too personal sent electronically, just because it's so easy just to type the wrong letter and have that critical information sent to the wrong person. As counselors, you have a duty to parents. Respect their rights and responsibilities. Adhere to laws. Be sensitive to diversity among families. Inform parents of the nature of counseling services. Adhere to FERPA. And work to establish collaborative relationships. You will get much farther with parents as your friends and as collaborative relationships that are working with you. You have a duty to students. Have an obligation to the students who are to be treated with dignity and respect as unique individuals, even if you don't agree with their choices. Be concerned with educational, academic, career, personal, and social needs. Respect student value beliefs and cultural background. and do not impose personal values on your students. Student counselors have a role and have a duty to schools. Support your students' best interests against any infringement of their education programs. Inform appropriate officials of conditions that may be disruptive to school missions while still honoring their confidentiality. Delineate and promote the school counselor's role and functions as a school advocate.
Suggestions and resources, not only for school counselors, but many of these suggestions can be applied to any professional working within the school system. Glassoff and Pate suggest the following. Know the applicable ethical codes. It's always important to be aware of your ethical codes, where to find them if you ever have questions on ethics. Know the applicable law in your jurisdiction. Also, you should always be knowledgeable of the school system and building policies and procedures. You could always refresh your knowledge of this information by way of professional readings and workshops and affiliations with professional organizations. You also want to practice prevention through education and involvement of the stakeholders. Make the parent and communities and teachers aware of some of the ethical codes that we must uphold. You also want to work diligently and specifically to make parents partners in the counseling process. I know that whenever I see a student more than one time on the same situation, I always try to include the parents. I even call them in to be a part of the counseling process and the relationship. And lastly, remember the 3 C's, consult, consult, consult. And that not only goes for counselors, that goes for teachers, that goes for administration. Whenever you're not particularly sure about a situation, it never hurts to consult or get the ear or the opinion of someone else. Resources. We were able to find a free training on legal and ethical issues for school counselors with Dr. Carolyn Stone. She's the former ASCA president. She's very knowledgeable of many legal and ethical issues that school counselors face, and we thought this information may be beneficial. I hope you enjoy it.
Resources. The Code of Ethics and Standards of Practice of the American Counseling Association, ACA, and the Ethical Standards for School Counselors of the American School Counselor Association, ASCA, are 2 resources available to help school counselors manage privacy and confidentiality in their counseling relationships. School counselors can also look to be moral principles or shared beliefs or agreed upon assumptions that guide the ethical reasoning of helping professionals. The moral principles most often cited in relation to ethical practices of counselors include the following: veracity or telling the truth, justice or fairness, non-malfeasance or doing no harm, beneficence or doing good, autonomy or respecting free choice, and fidelity or keeping promises.
Schools often have policies that all drug use information that comes to the attention of staff must be reported to administrators. Thinking of potential scenarios with students, at what point do you think it is advisable for counselors to report drug use, and at what point should they honor confidentiality?